From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Conflicting court rulings on an abortion drug create a legal clash that is likely to end up at the Supreme Court. It also further roils the politics of abortion. Plus, prominent Democrats say the Biden administration should defy a national injunction by a federal judge in Texas that would overturn a Food and Drug Administration decision approving that abortion drug, Mifepristone. How is this all going to play out in court and at the voting booth? Welcome. I'm Paul Gigot with the Wall Street Journal opinion page, and I'm here with my colleagues, Alicia Finley and Kim Strassel. Welcome to you both. Let's start with the dueling judicial rulings. Both came down late last week that have created something of a political and legal uproar. First, federal judge Matthew Kacsmaryk, if I pronounced that correctly, issued a national injunction against Mifepristone, saying the FDA had violated proper administrative procedure in approving the drug some 20 years ago. He delayed that injunction for a week to give the administration time to appeal to the Fifth Circuit Court of Appeals, which the administration has signaled it will do. Alicia, you've read all of it, all of the opinions. How strong is this ruling by Kacsmaryk, and is it going to hold up on appeal?
I think it's pretty weak. For one, on the question of legal standing, it's far from clear that the plaintiffs, in this case, the pro-life physicians, have suffered a concrete and particular injury, which is the threshold question to even bring a case in a federal court. The plaintiffs argue that allegedly adverse effects of the drug would cause emergency rooms to swell with patients, and that they would therefore have to take care of some of these patients, and that this could potentially expose them to legal liability and higher insurance costs, emotional stress and such. But these are all very, speculative injuries.
Haven't we had this in place for 20 years too? I mean, wouldn't those harms have demonstrated themselves?
Right, exactly. They could have actually produced evidence, and that they haven't. So they're saying, well, it's very hypothetical.
Could happen.
Right. And so I think this could be very well dismissed on that point, that discrete point of standing.
So that was the grounds he used. Kacsmaryk said they have standing, so then he could hear the case. And he upheld for the plaintiffs on what grounds?
So he ruled on the APA, the Administrative Procedure Act, which governs how agencies go about doing regulations, or essentially, in this case, the FDA, how it approves the drug approvals. And under the APA, administrative agencies must provide, reasonable explanations for what they do. And in some cases, when they're doing actual formal regulations, they have to provide notice and comment. In this case, the judge held that he looked at the evidence provided by the plaintiffs, some studies that had been done that show that there could be more adverse effects from the drug than the FDA claimed from its own research and the studies that it considered. And the judge said it was arbitrary and capricious because it didn't consider this other evidence that the plaintiffs presented in their lawsuit.
One of the things that puzzles me, Alicia, is that, this is a decision from 20 years ago. The original approval, they updated some regulations in, 2021, and that gave the opportunity for the judge to say that I can look at this again. But was it that significant a shift by the FDA in 2021 to kind of overrule all of its previous 2 decades?
So what the FDA did in 2021 was allow, and this was again during the pandemic, in part prompted by the pandemic, was allow the drug to be dispensed via the mail rather than in person. It previously had requirements that the drug actually be dispensed to patients in person. So it actually didn't reconsider its entire decision. And just going back to your point about the time span, there's actually a 6-year statute of limitations for challenging agency actions. Now, the plaintiffs will argue, well, we filed a citizen petition with the FDA. They sat on it for over a decade. They didn't actually respond to us until 2016. And therefore, we couldn't actually file suit until, after that. And still, they waited more than 6 years. So the judge even concedes, even then, 6 years has passed since the FDA responded to their citizen petition. And 16 years spanned 2 administrations. So this wasn't just occurring during a liberal administration or the FDA delay. This also occurred during the Bush administration. We don't know exactly why. But the statute of limitation has clearly passed on them challenging the approval.
All right. So at the same time, or we're almost the same time, a federal judge in Washington state ruled on a different case in a different way, ruled the opposite way, saying the FDA restrictions on the use of Mifepristone were too tough. This ruling was issued by Thomas Rice, an Obama appointee, whereas Judge Kacsmaryk is a Trump appointee. Kim, this was brought by Democratic attorney generals whose case may suffer from the same standing infirmity that the Texas case does.
Yeah, and can I just put this a little broader too? I think underlining just how political both of these cases are rather than legal is the blatant forum shopping that went on here. It's very clear that the doctors who filed this lawsuit in Texas did so in an area where there's one judge in Amarillo, Texas, and they figured they'd have a good shot there. And then in response to that, these Democratic attorney generals went and filed a lawsuit in the state of Washington, a far more liberal state, and ended up with a judge that they felt was going to help them, which I think just undermines even further the quality of these cases. We don't like to see forum shopping in the judiciary, but that is an aspect of this. And yes, you had these 17 attorney generals in Washington. They have argued that the FDA is actually too tough, imposes too strong of safety rules, and that this is harm the states. They have an equally weak case on the standing. There is no evidence that the states have suffered some sort of concrete harm from the safety precautions that the FDA has put forward. There's also another issue in that the FDA, there's certain administrative processes and procedures that you're supposed to go through if you want to appeal something that the FDA has done before you bring a lawsuit. They have not exhausted that process. So I think that, again, this should have been a judge that dismissed this for standing. And then there's this argument, again, about the notion that there is some sort of impingement upon people because of the FDA's safety rules. As you know, Paul, these have all been in place for actually 23 years. They were passed in 2000, approval was. As Alicia noted, they've actually even made it easier to dispense because of the COVID emergency. And so it's just an equally weak case. And it really does seem instead, we've got liberal and conservative groups that, having finally extricated the issue of Roe v. Wade from the judiciary last year with Dobbs, are just going right back trying to nationalize this issue again via the courts.
That's really one of the great ironies of this. Alicia, where does this go from here? I guess the administration will, well, they're not going to appeal the Washington state ruling. Somebody else might, I guess. But the Fifth Circuit will get to hear the appeal to Matthew Kacsmaryk's judgment. They could issue a stay on that national injunction while the case on the merits is heard. Do you expect that to happen?
I do. Again, the case has several different components to it because they were challenging not only the 2000 approval, but also several subsequent agency decisions, including the 2021 easing of the dispensing requirements, where I think the plaintiffs may actually have a slightly stronger case under the APA and the Comstock Act. But I do expect they will stay the decision pending a fuller hearing of the merits. And in part because if they don't, I expect an immediate appeal to the Supreme Court. And I'm not sure anyone really at this point really wants to do the Supreme Court. Well, maybe some of the plaintiffs do. But I don't think anyone really wants
the Supreme Court to do what?
To get involved at this point.
Okay, so let's say that the injunction is stayed, and so the drug will continue to be available. Then the case will move on the merits, and then the Judge Kacsmaryk will rule on more fuller opinion, and then that would go up the chain, probably to the Supreme Court, right?
I would expect so. The one thing that could force this up sooner is the clash with the Washington judge, because now you really have two clashing opinions or rulings.
I see. So the Supreme Court could decide they want to take this immediately without it going to the appellate process because you have this conflict in the two circuits.
Right. Or it could just, issue a stay of the Texas judge's decision if the Fifth Circuit itself doesn't.
Right. Would they decide the case on the merits on an emergency basis?
They could. They could do an expedited, in some recent months. I think they did that for the OSHA vaccine mandates. They've agreed to hear some cases on, on an expedited basis. So they could in this case as well.